Making an employment tribunal claim can be complicated. However, many people succeed and many others reach settlement. You can make a claim against your current, former, or potential employer. Some examples of claims are unfair dismissal, discrimination, and deduction to wages claims. A legal representative will normally do all the case and document preparation and act on your behalf at the tribunal. This will save you a lot of stress. If you would like to look for a representative, visit this page on Citizens Advice. Search on Google this phrase and click on this link. You can still represent yourself at court. In fact, the tribunal's overriding objective is to deal with cases fairly and justly, which means the tribunal will treat you favorably to put you on equal footing with your employer. In 2018, 43% of claimants did not use a day-to-day representative. From start to finish, there are roughly 4 stages to making a claim. First, you must go through Acas conciliation. Then you can submit a claim, followed by attending a preliminary hearing, and finally a final hearing. On average, it takes 27 weeks to go through the stages. However, the claim ends if you could settle with your employer. This could happen at any stage. Acas is an impartial organization that will mediate discussions with your employer to settle the dispute. 51% of disputes in 2018 settled in the early conciliation stage. You have 6 weeks to do this, and if you do settle, you must record the terms on a COT 3 form. If you do not by the end of the period, Acas will give you an EC certificate. To book their service, you must either submit an EC form online or phone their offices. Booking has no cost and only requires basic information. You can also be assured that anything said and shown to the Acas officer relating to the claim is not admissible in the tribunal without your consent. Submitting a claim is the second stage after early conciliation. You must submit an ET1 form either online or by post. You can only do that once you have an EC certificate. It contains an EC reference number, which you must put on the ET1 form. Make sure to submit the form within the time limit. For most claims, that's 3 months from the date of the employment issue happening. The form is your claim's first impression to the tribunal. It's a straightforward document that's mostly easy to complete, with some notable exceptions. You must make sure that you write it well because it's hard to amend later on. Section 8 is the most important part of the ET1. Ideally, you want to set out what laws you think your employer broke and provide a concise background of the most important facts. The judge in the 2020 case of CVD warned against using a narrative style of writing. The claimant wrote 37 paragraphs in that case. If the tribunal accepts your ET1 and your employer responds, your case now goes through the sift stage. Here, the judge will dismiss any claims outside the tribunal's jurisdiction and claims they consider have no reasonable chances of success. Before this happens, you'll get an opportunity to argue why you think this shouldn't happen. Don't worry, less than 1% of cases get dismissed here. After the sift stage, you will usually be assigned a preliminary hearing. This is the next big stage and an opportunity for the judge to familiarize themselves with your case and its complexity. The judge will estimate the length and date of your final hearing by asking you how many documents and witnesses you want to use. Also, judicial mediation, where a judge mediates settlement discussions, can be considered at this stage. Preliminary hearings can be ordered by the judge or requested by one of the parties. They come in 2 types. The first is a pre-hearing review. It's used to clear up any administrative matters. For example, some claims are only available to employees, so the judge will want to determine your employment status. Other claims require you to have worked for 2 continuous years under your employer. That too will have to be determined. The second type is a case management discussion. It's typically only assigned to complex cases like discrimination, and it's used to clarify the issues as much as possible and agree on a comprehensive timetable. To make sure cases run smoothly, judges use case management orders. It's a wide power to make all sorts of directions and orders to you and your employer before, during, or after preliminary hearings. But what and when orders are used is predictable to some extent. For example, it's typical for judges during preliminary hearings of either kind to order you and your employer to form a trial bundle, to exchange witness statements, to disclose and inspect, to provide a schedule of loss, and if the case is complex, to create a chronology or a cast list or both. Sometimes the judge may also ask you for a deposit. This is an amount of money you hand the court. If you settle or win, you get it back. If you lose, you unfortunately don't. All these orders will have a timeline by when you must do them. You and your employer can ask the tribunal at any stage to make a particular case management order. This is called an interlocutory application. Now, let's go through some of the most important case management orders. A schedule of loss is a document that you must create which sets out exactly what you want to get if you win the case. Disclosure and inspection is a requirement on both you and your employer to disclose all documents you're intending to use for the case, even if those documents support the other party. A trial bundle is a file of documents that the tribunal will look at during the final hearing. It is essentially the evidence backing up your claim. Usually, your employer will produce the bundle, partly because they have all the documents that need to be in it. You would need to discuss and agree with your employer what needs to be in the bundle. Sometimes there will be disagreement, and if so, you can make your own bundle. But for clarity, tribunals don't like having two bundles, so ideally try to agree with your employer. If you can't, you can ask the tribunal to decide on what should be included in the bundle. Witness statements are extremely important. Every witness you or your employer decide to bring must write a witness statement. It includes all the evidence the witness wants to give to the tribunal. It should be written personally by the witness and in their own words, so don't use legalese language. Anyone with evidence can be a witness, such as your doctor, who will be considered an expert witness. Witnesses don't have to read out loud their statements at the final hearing, but they can and will be cross-examined by the other party. You will typically be a witness to your own case, so your witness statement is extremely important because it gives your account of what happened. You will usually not be allowed to amend it later on, so make sure you don't miss out anything important. A chronology is a document setting out a timeline of important events. It's usually agreed with your employer. A cast list is a document with the names and roles of key people involved in the issue. Both are usually ordered in complex cases. By the time you get to a hearing date, you should have completed all the case management orders. The final hearing is where a panel, which includes a judge and two others if the case is complex, will look at all the case documents to make a decision. At the beginning of the final hearing, you would have to do housekeeping. This is where you discuss with the judge what documents should be there and what exactly your case is about. You and your employer would then make opening statements. After that, each party will have an opportunity to ask the other party's witnesses questions. This is known as cross-examination. Once that is done, you and your employer will have to make closing statements. These should summarize the facts and state what legal authority you're relying on, aka what laws or case laws you think your employer broke. After closing addresses, a decision may be given on the same day or at a later date. The decision will include whether you won and the remedies you're getting. If the remedies you're pursuing are complex, a final hearing may be ordered specifically for determining remedies. If your employer decides not to follow the decision, you'll have to apply for enforcement proceedings. If you're unhappy with the decision, you can appeal to the Employment Appeals Tribunal. but you must do that within 42 days of receiving the written judgment. If you're unsure about something or have any queries, don't hesitate to contact the Employment Tribunal's public line at this number. Thank you very much.